Hey, Brian Bean here with Dream Big Property Management in Riverside, California. We help people just like you become intentional rental property investors. Our clients often ask, what are we allowed to deduct from our tenant's security deposit when they move out? Well, let's start with the most important and misunderstood fact. First, a security deposit belongs to the tenant, not the landlord, not the property owner, not the property manager. It's the resident's money held in trust as security in case that tenant leaves the property with any unpaid fees or damages. With that in mind, when it comes to tenant security deposits, the penalties are severe if you do not handle it right. We're not attorneys. This is not legal advice. Our intent here is only to raise awareness. Consult with your qualified legal advisor for guidance on your specific situation. Now, when a tenant vacates a property, California law says that you must refund their security deposit in full within 21 days of a move out. There are ways, though, to deduct portions of it, but only for 4 specific reasons. First, unpaid rent. 2, to repair damage beyond normal wear and tear. Actual damages like fist-sized holes in walls or broken windows or damage from misuse. 3, cleaning necessary to restore the unit to move-in condition. And lastly, repairing or replacing items that the tenant agreed to maintain but then did not. That's it. Those are the only 4 things for which you can deduct. Now, here's what you cannot deduct for. 1, normal wear and tear. Worn carpet from foot traffic, that's normal. Faded or scuffed paint after 3 years, not a tenant responsibility. Small nail holes from hanging pictures, that's considered normal use. This is normal maintenance of the property, and it's borne by the property owner. 2, automatic cleaning charges. An assumptive cleaning fee is not allowed. You can only charge for items that were left unclean and only for actual costs to clean after the move out to bring that property back into the same condition as that move in. Another example, you can't charge an auto carpet cleaning fee if you're replacing the carpet. That's just common sense, right? 3, full replacement costs for paint and carpet. Paint and flooring have useful lives. Wall scuffs and some small nail holes are considered wear and tear. Carpet foot traffic, that's normal use. But even if there was significant pet stains or carpet tears from misuse, or if the tenant painted the walls bright colors without permission, you can still only charge the prorated amount of the repair based on the years of useful life left in that flooring or paint. Check with your attorneys for local rules on the useful life of such items. 4, upgrading or improving a property. If you're replacing old carpet with vinyl plank or tile, that's an owner expense. 5, pre-existing damage. This is a common argument, which is why pre-move-in documentation is so critical. And lastly, speaking of documentation, as of April 1st, 2025, California law requires a landlord to take time-stamped photos before move-in, after move-out, and again after any repairs in order to lawfully deduct any money from a security deposit. AB 2801 applies to move-ins on or after April 2025. If you deduct unlawfully, you could end up in small claims court and be liable for the money you held back, plus penalties and attorney's fees. So make sure that you are following the rules and document everything with time-stamped photographic evidence to back your decisions. If you have questions about security deposit deductions or anything related to the right and profitable way to run your rental property, call me today at 951-314-5402. I'm happy to share. You can also find valuable information on our website, dreambigpm.com. And if you found the information you heard here today useful, we have more, so check it out. Hit that subscribe button and we'll alert you when new information is posted. Don't be accidental about your future, be intentional. To your success.